Lord, in this case, the petitioner, my lord, was appointed as class 4 employee by the district judge within 6 months, my lord, before his retirement. Now,
Petitioner was dismissed,
petitioner's service, my lord, has been terminated now
terminated.
on the ground that he had been appointed by the district judge within 6 months before his retirement.
So what? Is there any prohibition?
That was, my lord, the executive order issued by the High Court. And, my lord, that was superseded in the year 1992 when the rule was framed.
What is the date of appointment?
Date of appointment, my lord, is annexure, my lord, 6. Date of appointment, my lord, is 14 to 1996.
14?
No, that is termination date.
Sorry. Annexure 6, my lord.
What is this, Mr. Counsel? You don't know few dates?
My lord, I am giving the date, my lord. Date of appointment, my lord, is 21/12/1994.
21?
21/12/1994.
Appointed as peon.
Peon.
Uh,
My lord, the advertisement
what,
had been
what is the date of issuance of notice of termination?
termination, my lord, is by annexure 11, dated, my lord, 14 to 1996.
Huh?
14 to 1996.
Termination?
Termination, my lord, on the ground.
Sir, what is the date of termination?
Date of termination, my lord, 14 to 1996.
No, you said notice on 14 to 96.
Annexure 11, your lordship will find. Annexure 11.
What is the date of notice?
Notice, my lord, that was given 24/6/1995, my lord, annexure 8.
24?
24/6/1995, annexure 8.
That is the only ground for termination.
That was the only ground that he had been appointed.
Where is the order of termination?
Pardon?
Where is the order of termination?
Termination, my lord, is at page 49, my lord, of the writ. 11, annexure 11.
Court officer, where is the writ papers? Writ papers. Page?
Page, my lord, 49. 49.
In the termination order, no reasons have been assigned?
My lord, this was exercised not by the succeeding district magistrate.
You are
Judge.
appearing for High Court?
Lordships, I am appealing for that.
No reasons have been assigned in the termination order?
Lordships, in the termination order, no reasons are there, but a show cause notice was there, wherein reasons were there. Actually,
show cause notice is annexure?
Lordship will see there are two show cause notices. One is annexure.
All right, where is the reference to the show cause notice and petitioner's explanation in the termination order?
Lordship, that is not there.
Then there is a total non-application of
Lordship,
mind.
it is a case wherein there was no post available.
We are not concerned with that.
Lordship.
We are concerned with the impugned order,
Lordship.
order of termination.
Lordship.
In the order of termination, it must reflect the issuance of show cause notice and his explanation. Then what is the object of issuance of show cause notice? Empty
Lordship.
formality, is it?
But now, Lordship, since the learned single judge has applied his mind and he has given reasons for dismissal of the writ petition after examining all the aspects.
No,
Lordship,
without giving opportunity to the petitioner.
Lordship, at this stage, Lordship, what I am submitting that at this stage, when the learned single judge has addressed on the merits of the matter and has passed a reasoned judgment, which is an appeal before a Lordship. At this stage, relegating on the point that whether reasons were there, Lordship, would it be
Huh?
would it serve the purpose, Your Lordship? That is what I am submitting.
What? 14?
Because the learned single judge has already examined the matter in detail and has on merits dismissed the writ petition.
No, petitioner has not been given opportunity.
That reasons were not there in the order, that is there. But
At least in the writ petition, during pendency of the writ petition, petitioner has been given opportunity.
during the pendency,
Where is the reasoned order of termination?
it is not there.
Ah.
That is
So
the,
whatever now you are saying that there are no posts before his retirement, these are all afterthought.
no afterthought. Before that,
Otherwise, you show me from the file. The decision has been taken.
Lordship. I'll produce the file, Your Lordship.
You want one more date?
Lordship's file is not.
No, otherwise we will give you quietus. Instead of giving appointment, you pay them 5 lakhs rupees.
Lordship's.
Because appointment is in the year 1994.
Lordship.
Now he is overaged for any other appointment.
And the writ petition was dismissed on the ground of delay also, Lordship.
Delay means
Lordship, the termination was given effect on 14th of February 1996.
96 termination.
And
the
99 writ petition was filed.
99 petition.
After 3 years, writ petition was filed. And one of the reasons for dismissal of the writ petition was delay also. No reasons were given in the writ petition for the delay also.
At the same time, there is a total non-application of mind.
Lordship, that is, but
If High Court passes this type of order,
High Court that is appended the.
or a district judge, whoever it may be, get instruction, lump sum 5 lakh rupees compensation, or else we will set aside. Because the order, the very object of providing notice is to see that a reasoned order is passed.
Lordship.
It is not an empty formality.
Lordship. That is there, Lordship.
Yes.
I can't. That,
You
that
get instruction, 5 lakh rupees compensation.
But it was a
The petitioner
totally.
is pursuing the matter since 99. We are in the year 2022.
Lordship,
Prima facie termination order is not a speaking order.
But there is a delay also on his part, Lord. He should have
All
immediately
right,
approached this court.
All right, the filing a
And,
suit is limitation is 3 years.
Lordship.
Same principle is applicable. In fact, for writ petition there is no delay. Only laches is required to be examined.
Right. Agreed, Your Lordship.
Correct?
Correct.
Now a limitation is taken 3 years. He has filed 3 years. 96 to 99.
Lordship, that is there. But another aspect is, Your Lordship, there was no sanction post and he was
Sir,
appointed.
that is your internal issue. You should have assigned all those reasons in the order of termination. You want him to give an appointment or compensation?
Lordship,
What is the age of the petitioner?
My lord, age is
not mentioned in the petition.
This appointment is after advertisement?
Yes, yes. Initially, Your Lordship, only 2 posts were advertised.
No, it's all right.
No, no.
Advertisement.
Yes, yes, advertisement.
He had applied.
Yes, he had applied.
Then it is after due process.
He was not selected initially.
absolutely wrong. He was selected, he was kept in list.
He
You
was,
know, some persons were appointed, some were kept
No,
in.
you have been placed only in the additional list.
yes,
Suppose if first person did not join in that event, you are entitled. Additional list is required to be operated.
My lord,
First
what?
person or second person, whoever it
what
may
the
be.
district judge did, that he created one vacancy by appointing that person as driver.
What action you have taken against district judge?
He had and he did so within 6 months of his retirement.
Correct,
And he
but
had retired
what action
thereafter.
you
What
took?
action you have taken against a district judge? Scot free.
I don't.
He is now dead. The gentleman is now dead.
You want to issue notice to the
Departed soul.
He has also retired, an old man now.
retired and died.
Might at
Yes,
least
yes, Mr.
Ah.
C.S. Lal
20
is
years
now-
old matter.
Brother knows.
Oh.
He is giving a hint. Issuance of notice to
Oh.
pay lump sum compensation. Because
He is
for
a,
no fault of the petitioner, you have issued order of appointment. Thereafter, you have issued a notice, and his explanation has not been considered, and you have not narrated on what ground his termination is.
but the
No, it's all right. Let him have a 99. He is pursuing now since 99. Five? For what purpose?
दिया हुआ है ना, उस समय नहीं था.
At least show cause notice is there.
yes, 2 show cause notices were issued.
In the show cause notice, have you narrated
Yes,
that
we-
the
yes. In fact, we have stated in the show cause notice. Facts are stated.
then why you are not reflected the same in the
In fact, Your Lordship, 2 orders were passed simultaneously, and in the preceding order, all the details were given, and thereafter this petitioner was terminated by the consequential order, Your Lordship. Both the orders are on record, Your Lordship.
Where is the first order?
And Lordship, the very previous order, prior to his termination, that is at Annexure 10, page 48.
he has worked for 2 years,
He had worked for 2 years.
1 year and 1 month.
No, this is notice. This is not notice. Terminated.
What is the name?
Lordship,
Ram
this-
Binay Rai.
28th August
Whether
1990.
his name is there in Annexure 10 series.
Lordships?
Where his name is there in Annexure 10 series.
No, in this order, the drivers who were appointed, they were terminated and they were sent back. One was sent back.
He is still working.
So he was sent back to his original post.
Everything had been not done at the instance of the High Court itself. This was my grievance.
How can you say that?
Because of the
Where
fact,
you have
my lord,
stated
my lord,
whether
In fact, there was.
Whether you have made this allegation in the affidavit.
No,
my lord, that had been made.
You cannot.
My lord will kindly appreciate. After appointment, my
Don't
lord,
pass casual remarks. without, putting
four
it in
per
affidavit.
5, my lord, some per 6.
You had the benefit of interim order.
Pardon?
You had the benefit of interim order in the 96, in the year 99. No.
My lord, in 1999, my lord,
You had
Prior-
the benefit of interim order.
my lord, what had happened in the case is, no,
Please answer, sir.
no.
Please say so.
No, I didn't get an interim order.
All right. Since you are not working since 14 to 96, we'll only
My lord,
give you some compensation. That's all.
my lord, my life has been ruined. That is the whole question.
Correct. But we have to see the law, no? We can't ignore the law.
My lord, so far as law is concerned, my lordship will kindly appreciate 2 things. What had happened, my lord, a list, my lord, was prepared after interview, etc.
Sir, we have to go by the whatever the law in the sense the number of posts existing as on that date. Because of district judge's fault, you have been appointed.
My lord, so far as the termination was, my lord, concerned, that was a completely fake.
Fake.
The matter is, the man
Please
is
submit
still
about your
working.
entry.
The
Don't
man
submit
is
about
still
your
working.
exit.
The man is still working as driver. Sorry, driver.
No, the petitioner is working.
Yes, still he is working.
Petitioner is working as a driver.
No,
Then
petitioner, one person, my lord, Jai Kishore, had been
Sir,
appointed as PN.
don't say that discrimination. Driver is working. I am a peon. I have to work.
No, no, no. What I am submitting is that one Jai Kishore, my lord, had been appointed as PN.
Sir, we are not concerned with that.
Subsequently, my lord, he was appointed as driver.
Have you challenged his appointment?
Pardon?
Have you challenged his appointment?
No, no, no. I'm
Then
not.
you can't have.
Kindly
You are
permit
not
me-
required to make
ki-
such allegations.
Kindly permit me to make one sentence more. His appointment was made as driver, then the post of the PN, my lord, that fell vacant.
Sir, that is the issue
That was the matter.
Huh?
Then that was the matter. Then this petitioner, along with others, my lord, were appointed subsequently, five persons. And my lord, it is said that he was appointed in the chain of driver, the PN Jai
How many
Kishore.
posts of peon were advertised?
Pardon?
How many peon posts were advertised?
My lord, several posts, my lord, had been advertised.
Show me from the advertisement.
My lord, list, my lord, I can show. I have given the list of selected persons.
Show me the advertisement. How many posts were reserved for peon post?
Your lordship will kindly have a look to page, my lord.
Advertisement.
33 page.
Advertisement.
Advertisement तो हमने नहीं दिया. I have not given that.
No, Annexure 2 is there.
Yes, get instruction, Mr.
Yeah,
Counsel. Get
advertisement.
instruction
Lordship.
relating to payment of compensation.
Lordship, sir, I'll get but Lordship, he is a beneficiary of an illegal process, which was
Beneficiary of?
an illegal process which was initiated by the learned district judge at the verge of his retirement. Only one person was
Sir,
responsible.
there is a default on the part of the office of the district judge.
Officer,
Then-
one person, Your Lordship.
Whatever it may be.
There was no approval by any higher authority, Your Lordship, at any stage.
Correct, that is a different, you should have taken action. What action you have taken?
That we can verify.
Huh? Just because he was a higher officer, you
Noted.
let him
Therefore,
compensation 2 lakhs rupees.
I'll seek instruction. Your Lordship. Let me seek instruction.
Is take down matter relates to selection and appointment to the post of peon. The petitioner, the appellant was appointed as a peon on 21/12/1994. Such appointment order was issued by a district judge, a district and a session judge, who was due for retirement within a period of 6 months from the date of the petitioner's date of the appellant's appointment to his term. The then district judge is stated to have committed error in appointing the appellant in other words, in the absence of a clear vacancy of a peon post, more than the advertised to his term. The same was noticed in the year 1995. Show cause notice was issued to the appellant. The appellant is stated to have submitted explanation to the show cause notice. Thereafter, the district judge, the district and session judge Madhubani proceeded to terminate the services of the petitioner, among others. To stop the order of termination reads as under 14/2/1996 reads as under. Full stop. Next, we have learned single judge has taken note of merits of the case, that the appellant has no right to appointment against a peon post in the light of the fact that such appointment was more than the against a non-existing vacancy. In other words, the then district judge had appointed peons more than the appointed more than the vacancy notified. Full stop. Further, order of termination dated 14/2/1996 was questioned by the appellant in the writ petition. After 3 years in the year 1999, even the aforesaid delay issue has been taken note of. First of, having regard to the fact that order of termination is very vague and there is no reference to the issuance of show cause notice and petitioner's explanation. First of, in other words, issuance of show cause notice and seeking explanation is only an empty formality. Full stop. The petitioner, the appellant was appointed on 21/12/1994 and followed by termination on 14/2/1996 has a civil consequences. Therefore, order of termination should have been speaking order. Full stop. We find prima facie case that the order of termination is not happily worded. In other words, there is no consideration of appellant's explanation. Full stop. In order to give quietus to the litigation, the respondents, the learned counsel for the respondent is hereby directed to get instruction to the extent that appellant is entitled to compensation of ₹2 lakhs. Full stop. Recently, Apex Court, in one of the matter, instead of extending service benefits, awarded a compensation of ₹1 lakh. Full stop. In this regard, learned counsel for the respondent is hereby directed to get instruction by next date of hearing list after 2 weeks. Remaining